there's this language they employ, and it is, in my view, it is the weaponization and criminalization by language that the FIA utilizes in these. So, are you saying asking a question now is a crime, or posing a question that leads to a conversation is a crime? Well, I think that this law is obtuse and vague enough to warrant such abuses, and which is why it is unconstitutional, which is why it should be struck down on the premise that it is an unreasonable restriction upon freedom of expression.
Hello and welcome to this episode of the DigiPod. My name is Farieha Aziz. Today I'm joined by Abdul Moiz Jaferii, who is a lawyer and is representing Farhan Mallick, the CEO of Raftar, who was recently arrested and charged under 26A in addition to other sections of Peca. Moiz, now this inquiry was going on since prior to the amendments, and then surfaces this FIR. Farhan is arrested in about 2.5 weeks. This entire process goes on till he's released on bail. Now, there's been a lot of conversation about the process itself. But if we could speak specifically about the newly amended law, but also the allegations against Farhan and the ingredients of the FIR, because in the last hearing, at the bail hearing, it seemed as if still it was not very clear, and you were asking the court, what is it that he has said, and how is the offense made out?
Hi, Freya. Thank you for this opportunity. As you saw, as was argued, that initially in November, he was told that you are defaming state institutions or something along those lines, or you are saying defamatory campaign. You're running a defamatory campaign. It was even vague as to who it's being run against, let alone what the campaign is, what it entails. And we saw that after 6 months, during which time he was afforded protection by the High Court, which was later taken away on a technicality. When they finally did file the FIR, they really had nothing to say. So there's this language they employ, and it is, in my view, it is the weaponization and criminalization by language that the FIA utilizes in these cases, where there were terms such as the alleged operator of the YouTube channel, namely Raftar. As in, there was this attempt to make it seem clandestine when all of this is on the record. There is no need to pretend that Farhan Mallick is someone who might be operating it and you've discovered this. It's all on the record. He admits that he is operating the channel. He admits that he's running it. So this use of language, one argument from the FIA could perhaps be that, oh, this is just the way we write. But in this particular instance, this use of language was trying to paint, above board, normal day-to-day things as if they themselves were the process of a discovery. So stuff like, oh, upon technical analysis of data, it was discovered. And this is basically them saying, oh, we watched a video. And they were couching it to sound like as if they'd done some very intrinsic discovery, after which they found out that, okay, we found a crime, they found a eureka moment. And whereas there's nothing there. And if they were to write down what actually transpired, which is that this is a TV channel owner, admittedly a TV channel owner, YouTube channel owner comes to see us, and we don't like what he says, and this is what we don't like. And, then we could have moved on from there, but it was anything but. It was this attempt at making it all seem very seedy, clandestine, that led to a process of discovery and investigation by the FIA, which wasn't the case. These were videos available online. And after building upon this storyline, they then go and say that, oh, he has been found to be running an anti-state campaign. And now, in the 6 months that they had from November till March, where they were authorized to run an inquiry, and they had issued a call-up notice, which is the formal, understanding that an inquiry is in process. They never put any specific data or any specific comment or commentary or any specific instance of news to Farhan Mallick, and they couldn't do it in the FIR either, and as you saw, they couldn't do it in court either. So even this convoluted and draconian law, even this requires that there be the false information that has been knowingly shared, that you've shared whilst knowing or have likely reason to believe that it is false, and that the net result of these two things, two ingredients, is a third essential ingredient to make it into a crime, which is that it affects the society as a whole, and it spreads a certain effect into the people, where it causes hatred or fear or whatever. So there are three ingredients. In Farhan's case, not a single one was met. So there wasn't ever an identification of news, let alone that the meeting of the separate test, that it was likely to be believed or known to be false news. And hence no requirement of the third test, which is that it caused an effect in society that was detrimental to whoever this mystery person or institution is.
Now, how does such an FIR stand is the question, right? Because, like you said, the call-up notices were vague, and this has been a pattern with the FIA. In addition to that, the FIR itself mentions a YouTube channel, but not any specific content, nor is there any qualification of what is that anti-state fake content, etc. It doesn't come up even in the initial stages when remand is granted or bail is denied by the judicial magistrate. And at that point, there's certain screenshots that surface, right? And really, when you read the challan, also the way that they have framed it, it seems as though if you've titled a picture a certain way and used certain thumbnails, that in itself has now it's the commission of an offense. In terms of, if we were to look at it in terms of legal precedent and what should or should not be able to stand, how do you see this FIR? And also then we'll come to the second FIR in which he's connected, as you have been saying in court, through hearsay in one line.
Yeah, let's tackle this separately because otherwise it would be just too much information, I think. I think their police file, again, this use of clandestine terms as if, they've done an investigation and found something. Their police file had screenshots in it. And these screenshots were screenshots of various videos that are available online on the platform. And again, how do these screenshots in and of themselves constitute fake news, deliberately known to be fake, and which can cause the relevant damage to the fabric of society? So and also the screenshots that were used by the judicial magistrate to deny us bail from the police file, all of them were misquoted. So they were all the bad boys of Karachi was misquoted to mean bad boys, as if it is alluding to some other term of reference to public servants. It was bacha bazi. Now, I fail to understand how that is a crime, and because he was speaking of child molestation and the curse of child molestation. That's what the entire title is. Now, where is Peca attracted in that, and what case are you trying to build here? That we don't speak about things that happen because we don't like to talk about what may or may not be happening. What's the line that the FIA is trying to take here? And also, there was Zillat Republic of Pakistan, which had a question mark. Now, that might be something that you consider in poor taste or unnecessarily aggravating, but fake news propagated deliberately, knowingly to be fake, and which would cause a damage to the fabric of society. I mean, how do you go about that? So are you saying asking a question now is a crime? Or posing a question that leads to a conversation is a crime? And so they really had, as you saw, they had no answers because they had no case, because they didn't have any material to build that case upon. And no matter how strict you can go with this law, you would at least expect that they would take, what I was expecting was that they would take certain snippets of what Farhan Mallick was saying and put them to the court and say that, look, we have discovered that this is news that he's propagating, and it may not have been news because Farhan doesn't do news. He's an analyst. He's a documentary maker. He's someone who tells a story. So he never attempts to be giving you any kind of news, breaking or exclusive or otherwise. So I thought that at least they'd do something where they try to stretch the meaning of the law and still show some of his analysis and claim that, oh, but it's being presented like it was news. But there was nothing. They had done nothing, or perhaps they had done everything and found nothing and had nothing to show for it. So it was a farce all around.
But the questions that also arise here is that they were still able to register an FIR of sorts, gain remand, bail was denied, a person's liberty, and of course, life affected. And what is the expectation of the judiciary to then stay the hand of a law enforcement agency or not grant them? Is there no requirement that looking at bare contents of the FIR connection to the offense? Because what is the Section 16? You misuse of identity information. What identity information? Or even
absolute farce, or dignity of a person. Who is this person whose dignity the FIA is now seeking to protect? There was 16 and 20 were absolute farce sections, and you're right. The role of the judiciary, and it's been, it's understood in the law itself. It doesn't need legal precedent to explain this to you, but then judges like Babar Sattar have explained it to you because of, practices that have emerged over time that are not strictly accurate or in line with the law. If the police remand is something that you obtain, so you are able to, because you're the FIA, you're able to detain someone on the presence of the FIR alone, fine. But then when you need to present them to a magistrate in 24 hours, that is the independent assessment of whether what you've been doing is lawful or otherwise. And it is there where the magistrate should step in and must step in and say, all right, so you've arrested this guy on the basis of this FIR. What is the information connecting him to the FIR, firstly? And if there is no information cogently found, then the magistrate has the power to discharge you from that FIR and get you away from this process instantly. So that should have been done in Farhan's case. It wasn't. And then thereafter, when they've arrested you, the magistrate, look, there's some requirements for physical remand, for investigative remand. So if you have to firstly show that you've got the right guy and you've got them for enough substance, but then you have to show that you now need him to investigate, which is why you're asking the court for time to spend interviewing or interrogating or going through data with him or doing something with that person, which will lead you to be able to build your inquiry further, that will be able to give you enough data to put in the challan. So, for example, if there were 4 burglars and you've caught one of them, you need that one so that you can investigate where the other 3 went, who they were. Or if you found a network of data pilferers, if you stay within Peca, then you found one server, and then to be able to connect to the other servers, you need that guy and his server to sit with and to investigate somehow and to thoroughly get to the entire network. These are reasons why you would need investigative remand. In Farhan's case, if you take the language and the weaponization of language aside, this is a series of videos that he has admittedly put on air that are there for the public consumption. There is nothing that you are alleging that there is a conspiracy behind these videos and that you've talked to person X or person Y who has maliciously or through the misfeeding of misinformation has given you information that you are putting online. There's none of this allegation. The allegation is just the content itself that's online. So why do you need him? Why do you need to sit on him? Why do you need to deprive him of his liberty in the interim period during which you're going to build this case against him? And I think that there was no test for remand, no case for remand made out. And even if he was considered lawfully arrested, the magistrate should have stepped in and sent him to jail custody, to judicial custody, instead of leaving him in the hands of the FIA. And I think that this practice of allowing the FIA, a certain amount of time in the beginning to do what they want in terms of investigation, regardless of the nature of allegations, is it's firstly a reflection of the state taking its arms of investigation legitimately. Because if you were to start denying FIA and police any right at all to investigate, you would, in 99.9% of the cases where they're actually doing their jobs, you would be depriving them of that right. So judges are, more keen on not going through anything at that first instance and giving them the time that they asked for or some of the time that they asked for. But in cases like these, I think it is up to the judiciary to stand up and recognize that it is this process itself, as you have yourself coined, it is this process that's the punishment. I don't think they're going to be able to get past the finish line with regards to any of the allegations they've placed on any journalist in Pakistan. I think the whole thing is to waste a man's 15 or 20 days, to make him spend money, to make him uncomfortable, to deprive him of his basic fundamental human characteristic, which is of freedom, and then to, in the process, teach him a lesson. And I think that was the case here. And as far as that second case is concerned, I mean, you've conducted an investigation. You've got a guy or a bunch of guys that are running some spoofing center or whatever, and the only thing you have connecting them to Farhan is that allegedly that guy said that, oh, Farhan is our sponsor, or our or he's a he's the senior statesman for us. And that guy, Farieha, even after those 5 days of remand were given, which should not have been given on the statement of a co-accused, that co-accused on each day turned up to court and said, I never said this. I have never seen this guy before. The first time I saw Farhan Mallick was in the lockup. And yet Farhan Mallick wasn't discharged from that case, which he should have on the spot, on that moment, but he wasn't. He was sent to jail custody, and then he got out 6 days later. It's a deliberate and bad use of law, and it is deliberate.
Further, and then again, there's a search and seizure, raids at the office, etc. Now, again, in terms of, here is a public video, even if they've got these screenshots, these are public videos. There's no contesting that this content is there. But in terms of, and why these cases don't proceed, in terms of the law, how they are supposed to make out their case, at these speech offenses, is it not necessary that at least the offense is made out, at least at a very initial stages, where they've just put in, what is contempt of Pakistan? What is contempt of state? There are all these terms that are just thrown in there. There's no qualification. Is the offense even being made out even in the challan? Now you've arrived at this
I
stage,
think
but there are no
I think
specifics.
Farieha, for a trial to continue, you have to put up the test of whether the offense is being made out prima facie. But for the FIR and for remand and for arrest, there's a lesser standard, but it's not met. And that standard is, are the ingredients of the offense made out? So forget that the offense itself is being made out. Do you have the necessary eggs, butter, and cheese that perhaps put together will make this cake of your offense? So do you have are the allegations you are making substantial enough to form the offense? So the allegations themselves weren't of substance. They lacked any cogent or required substance to show the necessary ingredients of the crime that is being accused of. So there was no identification of news. There is no identification of it likely being false or otherwise, and there is no identification of a natural person. So at least even the raw ingredients weren't there. Forget whether they will be able to be put together and turned into this final dessert product, as good or bad as it may be.
And what is also your view of the amendments, especially because now previously non-cognizable offenses such as Section 20 have been converted into cognizable offenses, right? So in terms of procedurally changing and the very basis of who can be a complainant, who's a natural person, or who a person is, all of those have been changed as well. How do you see this proceeding? Farhan's case, but also just the pattern that has emerged with his case under Peca.
Well, I think that this law is obtuse and vague enough to warrant such abuses, and which is why it is unconstitutional, which is why it should be struck down on the premise that it is an unreasonable restriction upon freedom of expression, and it causes for a lack of dignity in the entire process, and it gives the police too much power. It gives the executive too much power without judicial interference to create non-cognizable offenses, to create cognizability in offenses which are by definition non-cognizable, which by definition require judicial intervention to be made into or understood to be offenses. But even otherwise, I think in Farhan's case, they'll try to, the air kind of comes out of the balloon once the guy is out in any criminal trial, and especially in these ones where they know that they are substantially lacking. So you will see that the impetus on behalf of the FIA will be completely different. The amount of urgency the IO shows in this entire process will now be completely different. And they've already taken a date on the last date that it was put up for because they needed more time to investigate or put together a challan, and you'll see them kind of lose as much the sense of urgency that they had coming into this when they wanted to arrest him. And I don't know what case they'll try to set up once they put in the challan, the final challan. The interim challan is here. And I don't know what they will say in the final challan that they haven't already said in the interim challan, which is something that hasn't already been on the record for 6 months. But, you've seen how they prosecute once they finally get to prosecuting, especially in cases like these. They don't really have too much to say. So we'll see. They've cost him significantly in terms of his liberty, in terms of his time. Let's see how much more they do. But in that second case, I think even by their standards, I don't think it'll stand for too much longer.
If just as we wrap up, if you could also please summarize some of the arguments you have made. But of course, there are certain things that the FIA is bound by. There's legal precedent, there is case law, etc. In your submissions, you've also cited Subra BB, etc. So it's not as if we don't have certain, protections or limitations upon the investigation agency. What is it that people should be aware of that even though this doesn't, pan out in practice, on paper, this is still how it should be versus how it is applied?
Yeah, so bail being refused in cases where the punishment is less than 10 years and which doesn't concern heinous offenses, crimes such as murder, rape, bail is a right. It is a grace given by the court, and it is understood to be a right, one step less than a right. It is a grace, and the concession of bail not being afforded is an exception. So, even in the law as we see it today, there should be the creation of the exception. The court should tell you why it's creating that exception and not granting you bail, as the court didn't in Farhan Mallick's case. Whereas otherwise in offenses that come under the 7-year, 3-year banner and are bailable in their own right, that's where bail itself is a right. So bail is always affordable other than when something falls under the prohibitory limb, which is 10 or more years of imprisonment, which are crimes or crimes that are heinous in nature, where there is a clear test of denying bail made out, which is that you are a danger to society, you're a flight risk, or you have the capacity that if you were left at liberty in this intervening period, you would be able to affect the record, tamper with the record, affect the witnesses, affect the process of investigation. This is really the only reason why you should be kept in jail. And these tests are, almost farcical when you apply them to Peca. There is absolutely no way at any instance where they should be able to be applicable and someone should be able to be denied bail, but we see it happen. As far as precedent is concerned, yes, it takes the Supreme Court once every 10 years to correct what has become a police procedural wrong, such as Sughra Bibi, which said that you can't have multiple FIRs on the same transaction or the same allegation. You have to culminate that investigation. You can create as many sub-chapters of investigation within one larger umbrella. You can't keep repeating your allegation in the shape of new FIRs. And, whilst it came down for standard police procedural process, it has affected the way that the FIA is able to treat process as punishment. Otherwise, you'd see people like Farhan charged with 10 different FIRs in 10 different areas, and then their job would be in life to turn up to 10 different courts in 10 different areas of Pakistan all week. And it's Sughra Bibi that prevents that, to make a brief for bail. And there's a plethora of judgments where bail cannot be denied as punishment just because you don't like the guy, or just because you think that the crime is or just because you think his opinions are wrong, or just because you think that you don't like what he looks like or what he's saying, or is that's not a ground for denying bail. And almost exactly the reason why Farhan was denied bail in the first round was that we can't really condone these kind of acts. I'm sorry, that's not the test for bail. That's actually saying that I'm withdrawing bail or withholding bail as punishment. That's actually acceding to overturning decades of law, which says that that's exactly what you can't do. Just because you find something outrageous, or some of the headlines or some of the screenshots are so outrageous to you that you can't, you are creating the exception of not giving bail. But that's you saying that, yeah, bail should be withheld as punishment. Because the reason why you withhold bail is if the ingredients of withholding bail are made out, and they clearly weren't, because you weren't able to put that on the record. Some of the greatest developments in criminal law have been brought about by non-criminal law expert judges, because they look at it with a fresh, clean constitutional lens, and they come up with an opinion that is untainted with years of seeing police abuse procedure in practice. And I think, the judgments that Justice Manila and Justice Sattar have given on this issue of remand, and also on Peca, on offenses against a person, and where that standard of personhood should rest, and how likely it is to abuse, and how hence it should be struck off the statute. I think all of these things will have to now be repeated when a challenge to Peca is mounted, and it should be mounted, and it has been mounted. And the judiciary until now has responded by sort of asking how the people who individually have sued are affected. And I think now they'll have that answer in Farhan Malik, that he will show that he is in person affected.
Absolutely. And like you mentioned, Justice Manila's judgments, because there are a plethora of cases against journalists at that time, and call-up notices were also suspended. The same thing, that they are vague, they don't provide a copy of the complaint. There are instructions to the effect that there has to be a copy of complaint with respect to again, due process, and also that Peca has certain procedures. It's not like Peca doesn't state that the investigation with respect to a non-cognizable offense, that you first seek a magistrate's permission, but we still see that the inquiry, which has now been written into the amendments, but there was no concept of inquiry, it was only investigation as per 155. We don't see those procedures followed. We don't see ever a warrant for search and seizure. It's simply a raid. And in Farhan's case as well, they did seize devices, etc., for public posts, which they still haven't been able to really qualify what
Absolutely.
it
Yeah.
is that constitutes an offense. This is all we have from the DigiPod. Moiz, any final remarks that you would like to make before we close off?
No, I think just to re-emphasize that, as has been popularized by you, that the process being the punishment, and it's a classic and best example of showing how when the police would try to harass you, they would try to pick you up on a Friday night, so that it'd be hard for your family to find a lawyer on Saturday, so that it would be hard to find a hearing on Sunday. And this is the kind of process you're seeing on the hands of the FIA now, where 4 days before Eid or 5 days before Eid, let's get him, and then let's ruin a certain sacred part of someone's life, which will leave a memory for them to behave themselves, and for everyone else would serve as an example that even when we have nothing, we can ruin your life in a way that to any normal person would affect them for weeks and months to come. And it won't be, this is not something that is a forgettable or get overable lesson for Farhan Malik. Whether he's learnt that lesson or not, is a separate matter. But the fact that they tried to teach it to him and taught all of us else in the process, because Farieha, look, we're next. I've been saying this throughout these hearings that he was the first, but we're all next. If that is the standard, all of us are simply prey waiting to be picked up.
Absolutely. Nobody knows who is next and what the charge against you is. Even if it's made out or not, you will be tracked through the process, and that's all there is to it, which is why more people need to know about the law, more people need to push back. And there's enough for, as Moise has also listed, the judiciary there are enough precedents, judiciary has powers to curtail the abuse only if there's the will to do so. Thank you very much for joining us on this episode of DigiPod.